Finally have a quorum, so we're going to get started here. We have 3 bills today, and I'm going to ask Senator Robertson to open us up with a word of prayer.
Thank you, Madam Chair. If you'll bow your heads with me, please. Dear Heavenly Father, we humbly approach you today, Lord God, on another beautiful day, asking you that you'll open our minds and hearts, Lord God, with the wisdom that is necessary for us to lead this state. We ask that you'll remind us each and every day, Lord God, that we're only parts of the bigger solution, and many times we're parts of the bigger problem, and that we always, Lord God, lean into you for guidance. Ask all these things in your name and in the name of your Lord and Savior, your Son, our Lord and Savior, Jesus Christ. Amen.
Thank you, Senator. Okay, we're going to get started with Senate Bill 98. Senator Kauser, you have the floor.
Thank you, Madam Chairman.
Pull your mic a little bit closer.
All right.
Yeah.
Am I on?
Yeah.
Okay. So this one truly is a cleanup bill that you guys have heard about before. It's an agency bill. In our guardianship code, there is a list of preferences as who can serve as a guardian of an incompetent person, an aging person, in some cases minors that are unable to take care of their own affairs. And sort of the next to last on the pecking order of people that are appropriate to serve as guardians is called the county guardian. And counties will have an individual that they will allow to serve as guardian if there's nobody else. And if they don't have a county guardian, then it falls back to the state. And that's where Regina Quick comes in with the Department of Community Affairs. They have a division of aging services, particularly for elderly people. If they don't have relatives to look after them and take care of them, they're incapable of handling their own affairs, then the state gets involved in that. Guardians take care of a person and their affairs. A conservator takes care of their money, and sometimes these people will have financial obligations and resources, payments coming in, and when we revised the code some years ago, we sort of divided those duties up between a guardian takes care of the person, conservator takes care of the funds. The state really is not in a position to do that. We don't have the personnel, we don't have the wherewithal, because you might have a minor that you got 18 years you got to look after their money till they become of age. Or you may have an elderly person with dementia or other physical infirmities that may live for a decade or more, and so it becomes really almost impossible for the state to manage somebody's money or act as a conservator. I give you that background just because in our code, when it was modified some years ago, we failed to make a distinction between a county administrator or county guardian and a county conservator. And it was just all a county guardian, which really is not intended to be taking care of money. And so where there isn't a county conservator, it's been kicking back to the state of Georgia. And we just want to make sure that a county guardian will also have a county conservator position. And that's why that's all you're seeing in the bill, where they're adding the phrase county conservator, because that's now a little bit separately defined role from county guardian, and currently in the code it just talks about the guardian and doesn't divide the duties. And I hope that made sense. It took almost longer than I expected just to lay that out, where it just adding the word county conservator in various places in the code, since that is a distinct role from a county guardian, and right now the code only refers to a county guardian to handle both of those roles. Happy to answer any questions, and I have my dial-a-friend here with me. Counsel for the department is here, Ms. Regina Quick, and she can assist me if you stump me with a question.
Thank you, Senator, for that very clear explanation. And I should have mentioned we're working from LC 570226S. Is that the same thing you have?
That's it.
Okay. Senator Robertson, you have a question?
Madam Chair, I was just going to talk about how impressed I am with my colleague. A little while ago, we were in a committee meeting. He voted fiscally responsible, and now he's looking for efficient government. So when the time is right, I'll be happy to make a motion to pass.
Are there any other questions from the committee? Okay, you get off easy. So I think the time is appropriate.
Madam Chair, motion to pass.
Okay, and second by Senator Payne. Any further discussion? All in favor, say aye. Aye. Any opposed? Okay, thank you very much.
Thank you.
And I
Looks
think
like you got a quorum now.
Yeah, I've got a quorum, so I think you are good to go. Thank you very much.
Thank you, appreciate you fitting us in this morning.
Okay, our next bill is Senate Bill 100 by Senator Robertson. So would you go down to the witness mic, please? And this bill's going to look familiar to y'all from last year. Floor is yours, Senator.
Thank you, Madam Chair. Thank you, committee. This bill is very familiar. This is the third time I've had this bill here. The Senate has always treated this bill with the respect and compassion that it deserves. We've run into some stumbling blocks across the way, but we will continue to do the Lord's work and lead them to the promised land by making them more and more understanding of how important this piece of legislation is. Very simple. What this bill does is it allows a child who's adopted. Most children adopted today that run into this thing are adopted at birth. And after they're adopted at birth, their birth certificate, their biological birth certificate is amended to show their new parents. And what this bill does is when that child turns 18 years old, they can go to the public health department, like all of us can today. Those of us who are blessed to be biological children and know who our parents were, we can walk in there and I can ask for a copy of my birth certificate, pay the $25, and the state of Georgia gives me my birth certificate. It will give these children the exact same right. It will stop treating them differently than it treats we biologicals. And currently in the state of Georgia, if someone wanted to go down there and do that and they fell into this category, they would have to hire an attorney. They would have to get a hearing in a court, and after spending a few $1,000s on a very good attorney, they most likely would get a copy of their original birth certificate. All this does is save them money and treat them with the same amount of respect that every child who wants a copy of their birth certificate in Georgia deserves. And I do have somebody here to testify who has been familiar with this type of legislation before. She's helped us the last couple of years, and if I'm happy to answer any questions, and then she's happy to testify.
Okay, we are working from LC 442993.
Yes,
Is that
ma'am.
what you have? That's
Yes,
the
ma'am.
original bill?
Yes, ma'am.
Okay, let's take questions from the committee first. Senator Jackson.
Thank you, Madam Chair, and thank you, Mr. Whip. Who is Andy?
Andy is my 5-year-old adopted daughter who my wife was in the room when her umbilical cord was cut. I was not in the room. I was asked to be in the room, but I thought this young lady that was delivering this child had enough on her mind. She did not need to look up and see an angry-looking Santa Claus in the room. At the time, I had a very
wise.
robust beard, so I stepped out in the hallway, but stepped into the room and helped my wife clean up our baby, and her name is Anderson Naomi Robertson.
Thank you.
Thank you.
Senator Payne.
Is this the same language we've passed before?
It is. It's the exact same language. One thing that we've strived to do throughout this process was keep this bill as clean as we possibly could to avoid any confusion. In other states, they have done things that I think our good friend Senator Hatchett, as an attorney, understands. They do some things that just for show. It really has no legal binding where they add non-binding agreements and all this other stuff in here between birth parents and adoptive parents and everything else. But I think he will tell you if you ever throw the word non-binding in there, you're pretty much just wasting your time. But this right here is the absolute clean piece of legislation to accomplish what we want to do for these children who would love to know where they came from. Thank you.
Okay, and we have Jamie Weiss signed up.
Hi, good morning. It's a pleasure to be with you again. I appreciate all of the senators who've sponsored or who have supported this bill in the past, and we hope this is the year that we can get it through on the House side too. So I'm an adopted person from Georgia, and I am with the Georgia Alliance for Adoptee Rights. We have worked on this bill for many years, and it's all about equal rights for for adult adoptees. So just to be clear, it does not affect any adoptions of children, minors, whatsoever. It is only for adults. Also, one of the biggest things we've had to do with the bill is just to bust a lot of myths that exist. And one of the biggest ones is that there was some sort of promise of anonymity to a birth parent. And that is just not the case. And we can see that as evidenced by the policies, procedures, and laws of Georgia. That being that when a child is born, they're issued a birth certificate, and that is their birth certificate, unless they are adopted and an amended is requested. So it's not until that time. That could be months, that could be years, or they may never be adopted, because there's no guarantee when a parent relinquishes their rights. They've relinquished all rights, and going forward, they have no say over that child's documents. So that child may never be adopted and would always have their factual birth certificate. So we're just asking for equal rights for those of us who are adults who are adopted to be able to get our original birth certificates, the same as all other Georgia citizens.
Thank you very much. Any questions from the committee?
Perfect time, Mr. Chairman.
You had a question?
Is
Senator
it the
Jackson?
appropriate time?
It is the appropriate time.
Madam Chair, it'd be my great honor to make a motion that we move due pass on this bill.
Oh, second.
Second by Senator Payne. Any other discussion from the committee? Okay, all in favor, say aye. Aye. Any opposed? Okay, it's unanimous. Thank you very much.
Thank you, Madam Chair.
Okay, our next bill, Senator Anavitarte, you're up. This is a bill we have not seen before. So coming up to the witness mic, and are you bringing a friend with you?
We heard that.
Okay, and you want to introduce yourself, Mr. Wethington?
Yes, Madam Chair. My name is Jesse Wethington. I'm here today on behalf of Let Grow, which is a national childhood independence advocacy organization.
Thank you. All right, Senator, you're on.
Thank you. So I am working off Senate Bill 110, Committee Sub LC 49225-2S. And just want to thank y'all for having given me the opportunity to be here with Mr. Wethington, talk about child independence. So basically what this bill does, and the discussion we're going to have today, and I know Mr. Wethington's going to provide some comments, and we may even have some witnesses here to briefly just talk on this, but this whole notion of, parents being parents, kids being kids, and not us being so dependent on, child welfare agencies, social service agencies, and law enforcement to basically have to raise our kids. Me as a parent, allowing my kid to travel to and from school, walking, bicycling, traveling to commercial and recreational facilities like me and my brother did growing up every day, engaging in outdoor play, walking over to a neighbor's house, walking up to the grocery store that's probably 7 or 8 minutes from our house within our neighborhood, is not something that, should be criminal, should not be, considered as neglect, should not be considered as, anything other than just parents making reasonable decisions and allowing their kids to make reasonable decisions, or even guardians or grandparents within the family. I think, there's also an element here as it relates to the bill and what it does to ensure that a child that is sufficiently mature, has, the right, mental abilities per se, and avoid substantial risk of physical harm. I think as a family, as I watched, my daughters grow up, or even in the neighborhood I grew up in that had gang members and, not the greatest citizens in the state of Georgia, during our youth, being outside, having those kind of lived experiences, I think kind of prepared me, and my family for real life and kind of the things that we see day to day. And unfortunately back then, we didn't have social media like we do today. And I know the world has changed, but I think it's another reason why, to give, kids a little bit more leeway and give parents, kind of more ownership of their decision making. And if a parent does something really stupid or criminal or, that is true neglect, then yeah, I think that is where law enforcement, the juvenile justice system and others, should, come into play. So basically this law, or this proposed law, basically clarifies that neglect is the denial of necessary care to a child, creating an environment that is obviously injurious to his or her welfare. It tightens the definition of neglect, comports with the public's understanding that the state should not intervene in a family life unless the parent's actions or omissions cause serious risk or harm to the child that is obvious to a reasonable parent. Current law allows authorities to label parents a child neglector based on their own moral judgments without evidence of parents endangering a child or child's health or safety. So prime example is like even in some neighborhoods around Metro Atlanta, I've seen it with my own eyes, and depending on where you live, I'm sure y'all have neighborhood Facebook pages or other things, and parents will say, hey, there's a random kid walking up and down my sidewalk in the middle of the day. They're supposed to be in school. Nobody knows whether that's a homeschool kid. Nobody knows kind of the situation around that kid or what's going on. Some would probably call them nosy neighbors. And the next thing you know, the sheriff's office is called, basically asking this kid questions, and he was walking down the street, 3 houses down to go get, something from a neighbor and bring it back to the parent. And I think, from time to time, probably more than time to time, that's happening, especially as our cities and neighborhoods are becoming more populated, even in rural areas where I think people are fearful of crime, they may be fearful of other things. But I think we have to stop for a minute and just, ask ourselves the question is it really our job to police? And then, I'll pick on Senator Robinson, a former law enforcement officer. Is it my job to, bother the 911 center? Is it my job to, the non-emergent line to basically take away resources that are really serving and protecting a community, to basically go and quote unquote shake down a kid for basically minding his or her own business? Final comments I'll just make. I mean, good caring families are getting swept up in the criminal justice system, child welfare system, in many cases for no reason. And I just think, again, this independence conversation, while I think, a lot of folks believe that, we need to have greater, boundaries around our kids because of social media. I mean, I have every right to take away my kid's phone. My kids don't get phones until they're in high school, which is probably a little different than others. But that same kind of attitude, that same kind of personal independence that we have as adults, I think, it's our job to manage those situations and not the government's job or law enforcement or DFACS. This bill is passed in 8 states. Our current bill, we had a bipartisan support. The most recent bill passed in Virginia in 2024. In the committee sub, you'll see 2 changes. We deleted a reference to undefined standard that was provided to us and noted by DFACS, and we removed any language that related to hot car references in the language, as some of our colleagues pointed out. So, Madam Chairwoman, I'll turn it back to you and see if you have any questions of me or Mr. Weddington.
Did you have anything to add, Mr. Wellington?
No, I think Senator Anachardi did a good job setting it up. Again, I came to this issue, as many of you did. You probably were aware of the story of Brittany Patterson last year in Mineral Bluff, Georgia. She was wound up having an interaction with the Sheriff's Department as her son walked about 0.7 miles to the store. Again, this is bustling downtown Mineral Bluff, population about 300 people. That got some international press and wide play, in the press in Atlanta as well as in USA Today. I read that story and frankly, it made me a little mad. So I contacted Let Grow, said I'll be happy to volunteer to help support your bill. Called up my friend Senator Anachardi, and we appreciate his willingness to champion this issue for us. We've also provided the committee with a couple of letters of support. So this bill, there's both 2 statements from individuals who are part of Let Grow, Diane Redleaf and Lenore Skenazy. As well as a letter of support from the Reason Foundation, the Parental Rights Foundation, and Professor Peter Gray of Boston College that speak to the merits of the proposal and how allowing kids to be kids and exercising the kind of reasonable childhood independence activities that we all grew up doing and were normal, 10, 20 years ago, is a good public policy for the state of Georgia. We did, Madam Chair, have some individuals who had traveled here to speak to the bill from a parent and child perspective as well as from a legal perspective.
Thank you. We do have some people signed up to testify, and committee members, you've got 5 letters in your packet that you've probably already noticed, and a brief from one of the people who wants to testify, David DeLugas. So, questions from the committee? Senator Jackson?
Thank you, Madam Chair, and thank you, Mr. Chair, for bringing this bill. I have a child that I enjoy letting free range. I think this is the free range child bill, but I do worry about unintended consequences, and I'm looking at particularly this line 15 where it talks about acting reasonably they would not believe that the child was exposed to imminent risk. And I guess, common sense is not common anymore. What's reasonable in one eye of the beholder is not reasonable in the other. My wife and I, in fact, just had this debate. I think that my child, when he's 8 years old, should be able to go and sell eggs next door to the neighbors. And she thinks that that's dangerous because he'll have money and somebody could take him, right? We're both reasonable human beings, but it's not defined, right? And so I guess I just worry about, the very thing that you raise of some busybody neighbor calling the police, because in their reasonable eyes, that child is not mature enough for the independent activity. It just feels incredibly subjective. And I wonder, does this open up the floodgates for even more false claims or disputes among neighbors about whether or not the children in the neighborhood should be able to be running free or not? So I just, if you could speak to kind of your definition here and how we would kind of weight those things out to make sure that we're not causing more harm than good when we're trying to do this work.
Yeah, I'll just tell you, philosophically, in terms of, a kid in the neighborhood, I wouldn't be sending a child to another home unless I know who lives in that home. I wouldn't be visiting another home, especially under a certain age, unless it's, accompanied by an adult. I think, those situations, I think those are on us to kind of manage. I think that when we're going to, kind of getting into, what's reasonable in terms of, kind of by situation. An action has to happen, for, I think, law enforcement to, be called. Like, for example, kid on a 4-wheeler driving up the street at 2:00 in the morning, at a high rate of speed, maybe creating damage or even before the damage has happened, that would be highly unusual because kids shouldn't be out at 2:30 in the morning on a 4-wheeler, in a neighborhood. So, I think in terms of, what, the criteria in terms of what, at least from my perspective as a parent, what is right and what is wrong and what, the law would prescribe. I think it's clear. I do understand your concern in terms of, where situations could be vague, but I think that's where if the law is called, a series of facts or investigation is kind of looked into in terms of, what happens with that situation.
So I hear you. And again, I'm worried about the looseness of this definition. I had an incident in my neighborhood in which I had a bunch of 13-year-old kids playing with firecrackers in the middle of the street, and the neighbor's yard caught on fire. All these parents came out, and everybody had a different opinion about whether or not those 13-year-olds should have been allowed to play with fireworks or not, and whether or not that was okay or not. There was a lot of debate, and ultimately I told the kids, just go home because somebody's going to call the police. This type of definition, I am concerned because a reasonable adult can say there is imminent harm in a 13-year-old having a firecracker unaccompanied. One reasonable adult could reasonably say that, and another reasonable adult could say they're 13 and they know how to use firecrackers, right? I certainly shot firecrackers then. So I just want some help knowing that there's sufficient guardrails here so that more parents are not caught up like Brittany Patterson was. I want to make sure that we are not opening it up even more broadly when we're in fact trying to make sure that kids can do these things that we want them to do when it comes to free ranging.
Got it.
Thank you, Madam Chair. Senator Anna Vitarte, wouldn't you say when we try to define the word reasonable, there's two areas we can go to define the word, and probably the safest area we can go is the legal arena, where judges and juries determine what is reasonable and establish case law on what their definition of reasonable is. And then, of course, there's the common sense side of it, that each parent, to a certain degree, determines what's reasonable. And when those two don't necessarily, which is why we're here today, because obviously there was an arrest made by someone who thought their actions were reasonable. There was a dismissal by a judge whose definition of reasonable is obviously different than the ones that made the arrest. And now we're sitting here today as a General Assembly trying to better define that, hopefully to avoid judges and deputy sheriffs and moms and little kids being involved in this in the future, right?
Correct.
Because, you know, I grew up in that generation everybody heard about, where I was out till the street lights went out and rode my bike all over the place and trick-or-treated at every house except that one house. Apparently everybody had that one house in the neighborhood where the serial killer lived and feasted on children, so we didn't go to that house. But we do have to recreate a world where parents can be parents, children can be children, and let the legal decisions be made by those who wear the black robes and who serve their communities on juries. Would you agree?
Yeah, I mean, I agree, Senator. I mean, we live in a day and age, or even I grew up in a day and age where, you know, it was considered reasonable for me to go hang out with friends that carried weapons because we thought, you know, we would be safe, because we were worried about other gang members. We were worried about whatever the situation was. You know, for some that may be considered reasonable. In law, that's probably criminal, you know, just by association in those situations. And so, you know, unfortunately, there are parents who have kids that are being put in those situations. But then again, I think it goes back to us as adults and parents to basically, you know, create a pathway to where that is not, you know, being created a, you know, what is, quote, they may think is a reasonable situation in order to protect themselves without going together help from churches, law enforcement, or others to keep a child safe.
And I appreciate that, Madam Chair, if you'll let me, and I would like to follow up on something that Senator Jackson did point out, is that we may need to look at the fireworks law as we move this bill through and see what's in there. Because to be honest with you, sitting here, I'm not sure if a 13-year-old is supposed to possess fireworks or not. But I'm sure, you know, we'll be able to figure that out. And I will tell you, the hanging out with people with guns, I would look at constructive possession in some cases. But I know Macy Lynn's in the room, and I'm sure she would disagree with me. So thank you.
Thank you.
Okay, let's do this. We can certainly be thinking about the word reasonable while we hear testimony from the people that are signed up. And we have to be out of this room at 5 till 12, so I'm asking all the people that are going to testify to be brief. And if you guys want to step aside for just a minute, Mr. DeLugas.
Okay. Bo said that's reasonable.
Okay. All right, perfect. Thank you, Senator.
He's a lawyer.
He's a lawyer. It's reasonable in a legal sense.
That's right.
Okay, Mr. DeLugas, introduce yourself and who you're with.
Thank you, Madam Chairman. My name is David DeLugas. I'm a member of the State Bar of Georgia. I founded years ago an organization called National Association of Parents, Inc. We go by Parents USA. Coincidentally, our offices are in Atlanta, but our work is national. I filed amicus briefs in the U.S. Supreme Court, Idaho Supreme Court, represent parents in New York, Florida currently. We are in support of this bill, provided that the committee considers amending it to go along with a bill that I drafted that I believe addresses Senator Jackson's concerns and Senator Robertson's concerns as well. And first, apologies, I broke my right arm slipping on ice. Please avoid ice, which is why I am not shaved and do not have a tie on. I apologize to the committee. We have, as a society, acted on unreasonable fears, most recently dealing with COVID. According to Lenore Skenazy, who's with Let Grow, and I value her opinions, you would have to leave your child outdoors unattended for 750,000 years for your child likely to be kidnapped or taken by a stranger. Now, that's not how we operate in our society today. We all assume things are more dangerous now than they used to be when we were growing up, and we did have that ability and the freedom to participate elsewhere. And by the way, I am the attorney of record for Brittany Patterson, the North Georgia mom who was arrested, charged with reckless conduct, a statute that the Georgia Supreme Court held unconstitutional as applied in some situations due to its vagueness because it fails to give fair warning to parents about what behavior is and is not permitted. In the packet that I provided each of you, there is a copy of the arrest warrant that the deputy went out and sought within hours of finding this child in the four-way stop area of Mineral Bluff. And I won't go into all the details unless somebody wants to hear more about it, but here's where I'm going, and this absolutely should be part of the amendment. If somebody does call 911 because the parents in the neighborhood who see the kid with firecrackers calls 911, you know what should not happen? Immediately a deputy's dispatched. That shouldn't happen. Instead, the 911 operator should ask 3 questions. The child you're reporting that's at the park alone, that's walking alone, that's riding a bike alone, that's playing with firecrackers, do they appear to be hurt? Why do we need to know that? Well, we may need to send an EMT if they're hurt, they're bleeding, they have a broken arm. If the answer to that question is no, second question, are they in distress? Do they look frightened? Are they hiding? Are they crying? Are they in a fetal position? Are they curled up? Or are they just skipping along singing zippity-doo-dah and having a good time? And if the answer is no and no, the third question, do they appear to be in imminent danger of harm, significant harm, from an identifiable source? Not just that something could happen because this child is unattended. And if the answer to those 3 questions is no, dispatch then notifies deputies or a police officer and says, if anybody's in the neighborhood of such and such, check out a kid described as such as so tall, the ethnicity, height, weight, female, male, and then an officer drives up. And at that point, the officer does the same thing. Observe. Does the child appear to be hurt, in distress, imminent risk of harm? If the answer is no, no, and no, just drive on. In this particular case, Brittany Patterson's child was actually accosted or intervened by a presumably good intended citizen who asked him, are you okay? He said yes. Said, do you need any help? He said no. And she called 911 anyway. Well, at this point, the kid's walking away from her going, I don't know if I should be talking to her. The deputy was bothered because he didn't know his mother's phone number. I don't know anybody's phone number. It's on my phone. I don't even know my son's phone number. It's on my phone. The point is, what happened here is she was arrested. She was told she's being arrested for reckless endangerment. There is no such law. That's what the deputy told her. It's on body cam. The reckless conduct statute I just addressed. They brought her a safety plan that she declined to sign. It's called a safety plan, but as the saying goes, you know, the one that says if you call a dog's tail a leg, how many legs does a dog have? The answer is still 4, because just because you call it a leg doesn't make it one. Just because you call it a safety plan does not make it one. The safety plan provided Brittany Patterson would download, while being observed by somebody with defects, a GPS app to her child's phone that he would then have to carry at all times, which means it has to be charged. He remembers to take it with him. He doesn't forget it. The battery doesn't fall out, and there's cell reception. And that she wants her child to have a phone. As this good senator said, not every parent wants their child to have this phone. So DFACS is now involved. What is happening? We're using valuable, finite resources of law enforcement and DFACS in this case. So what's happened recently? You are the second people to learn this beyond Brittany Patterson. On February 7th, the good district attorney in Fannin County did not dismiss, and it's in your packet, filed a warrant dismissal saying, quote, additionally, discussions with the law enforcement agency and the passage of time since the incident have revealed no new issues or developments related to this case. As such, the state will not be moving forward with the prosecution of this case at this time. A newspaper article in the local paper followed up and said, quote, according to the district attorney Wood said he made the decision to dismiss the warrant because there had been no further incidents reported since the arrest. Now, all of you are,
Can you wrap up? We've got
yes. The chilling impact of this dismissal, so-called dismissal, and the newspaper article is evident. If it happens again, we're going to come get you. It's telling every parent in the state of Georgia, yeah, maybe we shouldn't have arrested her, but we could have, we should have, we were entitled to do it, and we'll do it to you, which means all parents are going to drag their kids indoors and not let them out. So we support SB 110, but we commend it to the protocol that's shown as the exhibit at the back of your packet that requires law enforcement dispatch to ask those questions, law enforcement to observe and ask those questions, and in the absence of an affirmative on one of those three, no action to be taken by DFACS or law enforcement. Thank you. Any questions?
Thank you very much, Senator Robertson. And regarding any amendments, that would need to go through the bill's author. So there's opportunities to talk to him at a later time, but we have to have amendments ahead of time in here. Thank you.
Any question? No?
Yeah, I have a question if you don't mind.
Yes, sir.
Yeah, your law practice, you primarily practice up in North Georgia?
No, sir. I practice Metro. I've been in practice since '84 in Georgia, and I practiced throughout the state.
Okay, but
now
your primary Metro?
in my private law practice,
Yeah.
Parents USA is national.
Okay, okay, thank you. So last time you were in the Fulton County 911 Dispatch Center,
Never been there.
never been there.
Yes, sir.
I'll tell you something, these are some of the hardest working men and women you're going to find in law enforcement, and they're getting calls like bullets flying in there at them,
Yes.
life and death calls. I want whether it's a healthcare call, whether it's a criminal call, whatever it is,
Yes, sir.
and you're thinking, and I have to think this possibly comes from a place of emotion, because I don't know how many of these cases, and I appreciate your
No,
change
sir.
of expression.
Not emotion at all.
Okay, yeah, I'm real good at keeping that out too. But what gives me concern is I think the original bill addresses a lot of the issues you're trying to amend. I think what you're doing is directing 911 dispatchers to ask specific questions. You're opening up, not only, I think, are you encumbering the tradition, and these are post-certified 911 dispatchers. These aren't
Yes.
people they just hire off the street to come in there and run this multi-million-dollar equipment. And to ask them to ask these minute questions of not subject matter experts, because if Johnny wears a particular type of prosthetic and he's walking down the street, I don't know if he's injured or not. So if I give the response, yes, he appears injured, then I'm giving a bad response. So that deputy goes from just a drive-by call to a blue light and siren call. Then it seems like we may aggravate the situation more than need be. I think from listening to your testimony, what we had here is we had probably a helicopter neighbor that was a little more interested in a child walking unattended than maybe they would have allowed their children to do. And for them to have, and to use your word, accost this child, I would love to know if their intent was to make sure the child was okay, or if their intent was just to be nosy in that case. But I think what and look, the deputy on the saying, reckless conduct and all this, I agree with you 100%. Sometimes individuals throw out the wrong term with the right intent. And in this case, they did throw out the wrong term. But I think to overcomplicate this gives this legislation a better chance of not going anywhere than to keep it clean and focused on where it needs to go. And I appreciate your testimony.
Thank you, Senator. As you know, 911 calls are made when people's pizza doesn't arrive on time, and they have to deal with those as well and fend them off.
I promise you, I've worked in those centers and I've watched people work in there, and you're absolutely right. They are used and abused. Absolutely.
Agreeing.
Thank you very much. Next, we have Jackson and Beth Widener. Widener, come on up, and we're getting short on time, but appreciate you being here. Thank you.
First, I'd like to thank you for your time, your attention to this matter that affects families across the state, and for the opportunity to be part of this legislative process. I'm a 13-year-old Georgian resident, the youngest of 4 siblings, and I've had the privilege to be homeschooled through my entire education. A core part of my family's homeschool philosophy has been training independence in and out of our household, to build skills to be adults who are wise decision makers with functional independence and good judgment. As a result of decisions my parents have made to provide us with the freedoms they deem necessary to accomplish these goals, my siblings have been questioned by strangers and even detained by police officers. I have strong opinions on the definition of neglect and childhood independence because when I was younger, I went to Ingalls, less than a mile away from my home, on my own to take advantage of a free cookie. I was detained by police officers, and my parents were threatened by DFACs. In fact, over the course of a year, I was detained 4 times, and on 2 separate occasions, my family was subjected to questions by DFACs, all for engaging in reasonable childhood freedoms like biking in the park alone and visiting a comic book shop with my brother. We all believe parents should have the freedom to make reasonable decisions about the care, protection, and training of their children. As a child, I was robbed of these rights to have my parents make those decisions without the threat of intervention from strangers and government agencies who had different opinions. Because of these experiences, I learned to see police officers as a threat. This should not be the case. This committee should amend the Georgia law regarding neglect to that legal custodian have necessary protections to permit a child to engage in independent activities that they reasonably believe the child is sufficient maturity, physical and mental ability to avoid substantial risk of harm so that the children can grow and develop into self-sufficient adults through independent play and reasonable responsibility. I should have the right to be cared for by parents who have the freedom to raise me in the way they believe is best. And I believe that other families should have the same right without fear of being investigated. I urge you to support State Bill 110 and help kids like me have the freedom to grow, learn, and experience childhood in the way it was meant to be experienced.
Thank you, Jackson. Good job. Beth?
Hi there. I am Jackson's mom. I'm a lifelong resident of Georgia. Can you hear me good? Yeah. All right, and I'm a mother of 4. I'm committed to parenting my kids to be functional adults, capable of making wise decisions and contributing to their community in meaningful ways. My husband and I believe that encouraging appropriate independence and freedom is necessary for healthy development of our children. How can we expect a child to navigate the responsibilities of adulthood without providing them with opportunities to train skills and to test their views of the world around them? This is one of the best gifts that we've been able to give our children. The opportunity to make choices and experience freedoms and consequences of their choices while they're in the safety of our care. Currently, my children are 19, 17, 15, and here's my youngest, Jackson, who's 13. My daughter works as a florist, and she attends Gwinnett Tech. My 17-year-old dual enrolls at KSU, and he's going to graduate with just a few credits shy of being a junior in college from high school this spring. My 15-year-old is active in a military science program with a local private school, and Jackson here loves boxing and video games and his dog. They have started businesses. They serve in their church and community. They play Frisbee with their friends, and they've walked through the woods into the grocery store on their own. But they're far from delinquents. They, in fact, engage meaningfully in their communities now. No one looks twice if Jackson walks to the gym on his own now. But back when he was a little guy riding his bike in the park and enjoying those forbidden cookies, our family experienced very inconsistent reactions from police officers and DFACS agents. We were told by one police officer that you can't just let kids play like that anymore when he was found on his bike in the park. My husband was threatened with arrest for contributing to the delinquency of a minor and told that he could Google the statue himself when he asked under what grounds. We were finally on the 4th time that we had contact with a police officer. We were told that she understood our position but was required to return Jackson home. We were questioned by 2 DFACS officers. They came to our house as emergency visits. One said our kids were obviously well cared for. She took the time to walk the park system that Jackson had been playing in from our townhouse. There were no streets that had to be crossed to access it, and crime rates were low there. She said she would have allowed her own kids to do the exact same thing given the same circumstances. However, on the next visit, before the DFACS agent was even in our house at our table, walking down the hall, she said, "I'm here because you have a supervision issue." She tried to force us to sign a parenting agreement, and she left our house threatening that she was recommending a formal case be opened against us. A formal case was never opened. These inconsistencies in understanding and enforcement of the current laws related to neglect show that this committee should amend the Georgia Code regarding neglect so that legal custodians have the necessary protections to permit a child to engage in independent activities that they reasonably believe the child is of sufficient maturity, physical abilities, and physical abilities to avoid substantial risk. This committee should protect parents' rights and make reasonable decisions about the care, protection, and training of children. Helicopter parents and free-range parents alike deserve the right to choose the freedoms and restrictions for their own children. Thanks for your time.
Thank you for your testimony. We have one more person who signed up, Doris Good.
I'll be very brief. My name is Doris Good. I'm a parent's attorney, which means I represent, in my practice, 90% of parents who are accused by DFACS or CPS of abuse and neglect. Obviously, we are in support of the bill. We think that there's already too much unnecessary intervention into families and children in this state. I am essentially here to see if you all had any legal questions as far as how that may affect the process that we're involved in every day.
Senator Jackson.
Thank you, Madam Chair. So hopefully you've heard my
Yes.
raising some questions about does this language protect parents or not? Do you have any concerns when you read this bill? Does the language around reasonable feel sufficiently defined enough to protect a family like the one we just heard from?
I do, and I think that mainly, well, let me back that up a little. If police officers and DFACS employees are appropriately and properly trained, yes. Unfortunately, we are going to have those folks who are not. I think that this is a good step in the right direction. I think that in our work, we consistently deal with what's the definition of reasonable, whether it's reasonable efforts to get children home or to get them with other folks. So I think particularly with DFACS case managers that they're very aware of those standards and they've used them consistently and daily in their work.
May I ask a follow-up?
Yeah, make it quick, please.
Yes, so, and
I'll
your
talk quick.
just based on your experience, if we didn't change the statute, do you think that properly trained police officers and caseworkers would still be arresting or attempting to arrest families like the one we heard?
Yes, I do.
Okay.
Thank you, Senator. Thank you very much, Senator Anavatarte. You want to come and close?
Thank you. I just asked for a favorable consideration.
Any further discussion?
Move to pass, Madam Chair.
Second by Senator Hatchett. Okay, any further discussion from the committee? All in favor, raise your right hand, please. Any opposed? Okay, thank you very much. Your bill passes.
Thank you, Madam Chair.
Meeting's adjourned.